Good morning, everyone. Honorable Chief Justice is here, and we're about to start the program. Please be seated.
Good morning, everybody. The dignitaries, all the respected Supreme Court judges, High Court judges, the district judges, senior advocates, advocates who have put in enough number of years here. We all want to now greet the Honorable Chief Justice, our chief guest, who has now arrived. And let us start the session. May I request Honorable Chief Justice to please. We are told that Honorable Chief Justice is running short of time because of some hectic schedule and definitely is being wanted everywhere. So, and he's trying his best. He can't say no, he couldn't say no to us, can't say no to anybody else as well. So possibly he's living 100 lives in a day. But then we requested him to extend his address as long as he can, then felicitate the young Turks who had actually helped us in making this event happen, this conference happen. This is the first ever national conference of women in law, Indian women in law, which we very dearly call iWiL. And one of my friends today messaged, she said, I will, we will. And we use a tagline, yes, we can, we shall. I always say when the women come in this number, just see the colors of the hall. We wear the colors, we wear the mind as well. We just wanted to make this statement that don't mislead or misread us by the colors we wear. We really brain up on the upper floor. So you can consider us good for further progression. May I now request my dear friend, very, very dear friend Pavni, to give a welcome address. We all know her. She doesn't need an introduction. She's the woman who started the first women organization association in Supreme Court. Since the time is short, we are not speaking much. We have to really let our chief guest speak the earliest possible. Over to you.
Namaste and a very, very warm welcome to the Honorable Chief Justice of India, Shri Suryakant, esteemed Supreme Court judges, esteemed High Court judges, members of Parliament, members of the District Judiciary, my dear colleagues and friends who have traveled from all parts of India to be here on this day. Today, I stand before you to speak on a matter that goes to the heart of justice, equality, and democracy. Why women must be adequately represented in the judiciary of India. Our constitution begins with a rather futuristic preambular aspiration of securing justice, social, economic, and political. It is a promise shaped by the vision of our founding fathers and mothers. Yet, in retrospect, the composition of our higher judiciary, a more pressing question that faces us is, does the higher judiciary really reflect the society it serves? Justice is not an abstract idea. It is interpreted, shaped, and delivered by people. The Constitution of India is a living testament reflective of the realities of the citizens it seeks to protect. And when the people interpreting the Constitution reflect the diversity of the nation, justice becomes more profound, more inclusive, and more trusted. To achieve this vision, we need a judiciary that embodies constitutional morality and inclusiveness. The inclusion of women on the bench does not mean preferential treatment or ornamental representation for that matter. It means fulfilling the constitutional promise of equality and reflective of gender equity. It means ensuring that all interpretation of laws reflects the lived realities of all citizens. Women constitute nearly 50% of India's population. However, their representation in the higher judiciary has historically been minimal. While we have had pioneering figures like Justice M. Fatima Bibi, who became the first woman judge in 1989 of the Supreme Court of India, however, the journey to equity has been ponderous. A judiciary that reflects the diversity of society, including gender diversity, inspires public confidence in the legal system. When women see themselves represented on the bench, it reinforces their faith that the system understands their realities and experiences. This becomes imperative as the hardest task of a judge is not a mere mechanical application of statutes. It involves interpretation, sensitivity, and an understanding of dynamic social context. Women judges bring lived experiences that are crucial in cases involving gender-based violence, workplace harassment, reproductive rights, family law, domestic abuse, etc. When women occupy positions of authority in courts, they challenge deep-rooted stereotypes that leadership and legal authority are reserved male domains. Every woman judge becomes a role model. She sends a powerful message to young girls across India. You belong in spaces of power. You belong in courtrooms. You belong in decision-making positions. This sense of autonomy, agency, leadership, and professional conduct sparks inspiration and that travels well beyond the corridors of the courtroom. The lack of women jurists today is due to structural and societal barriers, from unequal caregiving responsibilities to limited mentorship opportunities. Women face systemic challenges in climbing the legal ladder. Our purpose here today is to engage in a meaningful discourse to first identify and acknowledge the varying issues surrounding the appointment of women as jurists, and then come up with meaningful suggestions to solve this crisis. India has produced remarkable women jurists, from Justice Fatima Bibi, who broke the highest judicial glass ceiling, to Justice Leela Seth, who demonstrated that leadership and integrity know no gender. From Justice Ruma Pal and her fearless defense of judicial independence, to Justice Nagratna here today, whose dissents have enriched constitutional discourse. These women have strengthened and not weakened the judiciary. Women should be on the judiciary in India not as a matter of charity, but as a matter of constitutional necessity. A bench without women is incomplete. A judiciary without diversity is limited. And a democracy without equal representation is incomplete. Let us strive for a judiciary that truly mirrors the people it serves, a judiciary where women are not exceptions but equals. Thank you, and I wish you all a very happy iWiL Day, Indian Women in Law Day. I now request my dear co-organizer, my younger sister Shobha Gupta, to take on the mic and address you on the inaugural address. Thank you.
Thank you, Bhavni. As she always would, spoken with heart, firmness. Now my job is, and I have to really squeeze it in 2 minutes, though I was allotted 5 minutes, but I'll do that fast. I have to introduce the whole conference, why we are doing this. So, see, we are now 75 years old as a nation. I'm just roughly saying it. We adopted the Constitution now 75 years back. Equality had to be there, equal treatment had to be there, but why we are now standing at a stage where we have to still have this conference today in 2026. The very fact that we had to plan a conference speaks volumes about the need, the fact that we are somewhere lacking behind. We had to really sit together, trauma-headed, to see why we have, where we gone wrong, what really has to be done to now correct what went wrong, what is the way ahead. And this is the time we need to really sit. We are saying as a women of this country, now please let us put everything together, tight the loose ends, and whatever need to be done, now do it. This is the time when it has to be done. It is possibly for us the high time to keep waiting for the due to arrive. And that is the reason we have actually divided this conference in 4 sessions. The first session is about the roadblocks in achieving the constitution mandate and equal representation and the roadmap ahead. We really would be looking forward for this first session, the panelists, to speak frankly, with openness, to say and to really see and discuss, debate, where did we really go wrong? What possibly would be the solutions? Second panel or the second session is to bridge the gap now. So first session, we are discussing what went wrong. Second session, now please try to bridge the gap, balance the bench. And you might consider us greedy, but our demand is 50%. We are in the population 50%. You can see the claps, they all are asking for that. That's the third session, which would be the post-lunch, is inclusive benches. We all can vouch, the female judges sitting here, and the best example is Justice Nagaratna sitting over here. The inclusive benches does make a stronger bench. I am witness of that in one of the matter. So we can say that that is the highlighted one. The fourth session is that what I have already spoken, half the nation. Please vouch with me for that. Half the nation, half the bench. So if you are 50%, 50 vacancies, please fill 25% by the half the nation. Thank you so much. We are now call upon the first session panelists to be there. And before that, since Justice, I'm so sorry. These all would be happening. May I now call upon Honorable Justice Suryakant, Honorable Chief Justice of India, our chief guest, to give us the inaugural address. His time is short, but we would be requesting him to compensate us by speaking for a longer period within that inaugural address. If we are going to miss the panel, please, sir.
Thank you.
Thank you.
My esteemed colleagues from the Supreme Court of India, led by my distinguished sister, Justice B.V. Nagaratna, Justice N.V. Ramana, Honorable former Chief Justice of India, Honorable Attorney General for India, a galaxy of Chief Justices, sitting and former High Court judges, representing various High Courts, Shri Vikas Singh, President of the Supreme Court Bar Association, Pragya Baghel, Honorary Secretary, Dr. Monica, Senior Member, and other executive members of the Supreme Court Bar Association, a galaxy of eminent senior advocates, including the chief organizers Mahalakshmi Pavani, Shobha Gupta ji, Meenakshi, Dr. Menka, Dr. Monica, and in fact, if I will start naming all of you, it will take some time. Very distinguished jurists, senior advocates and advocates, scholars, institutional leaders, ladies, hardly any gentlemen, friends from media, my sincere apology for being late. I am coming from Chandigarh. There were some significant events there yesterday, but the morning event I didn't want to miss. On the International Women's Day, the Chandigarh High Court Bar Association and various other platforms had jointly organized a walkathon, and I wanted to participate in it. Because of that, I got late. It gives me immense pleasure to participate in this inaugural session of a very thoughtfully conceived and executed program. And before I proceed with my address, I must congratulate and commend. They really deserve a lot of commendation, the organizers, Indian Women in Law, for this enterprising initiative. Heartiest congratulations to all of them. As I look across this auditorium, I am reminded of the understated but formidable courage that defines so many women in the legal profession. There is a distinct kind of strength required to enter spaces where one's presence was not historically assumed, to claim one's place and to steadily reshape the conversation. It is worth recalling for all of us that barely a century ago, under the regressive colonial regime, women in this country were not even permitted to practice law. The distance traveled since then has been substantive, but it has not been accidental. That progress has been earned through decades of perseverance, through service rendered often with spectacle, without spectacle, through barriers confronted with fanfare, and through competence demonstrated repeatedly in the face of doubt. On this 8th day of March, a day globally observed to honor the achievements of women, it is important to acknowledge that the journey toward full and equal participation in our institutions remains unfinished. And unfinished journey require studied reflection. To that end, late Justice Fatima Bibi, the Supreme Court's first woman judge, once eloquently remarked with her characteristic simplicity, she said, and I quote, "I have opened the door." Those words marked a historical moment in 1989. More than 3 decades later, the responsibility before all of us is to ensure that the door she opened does not depend on individual exceptionalism. It must remain open not by circumstance, but by structure, sustained by institutional will rather than personal breakthroughs. The theme of this conference, "Half the Nation, Half the Bench," is such a profoundly timely and resonant topic for today's discourse, one that is perfectly aligned with both the urgency and the opportunity of our time. A sobering reminder that when half of India's population looks to the institutions entrusted with safeguarding constitutional rights and finds only limited reflection of its own experience, the concern transcends statistics. Rather, it goes to the heart of institutional adequacy. Pertinently, it concerns the confidence of approximately 650 million Indian mothers, sisters, and daughters who must believe that the justice system understands their realities and will respond to them with fairness. We all know that women who ascend to the bench did not bring a separate standard of justice. The Constitution remains the same. The oath remains the same. The office remains the same. What changes are the lived experiences that inform judicial perspective. Women often bring distinct insights shaped by how law operates in homes, workplaces, and everyday realities. Consequently, their presence does not merely add diversity to the bench, it deepens the court's engagement with the society it serves. By broadening perspective, our jurisprudence itself is enriched. But to speak only of what women contribute without acknowledging what it has taken for them to reach here would be to tell only half the story. The legal profession, over time, has unwittingly developed a working climate that imposes invisible costs disproportionately on women, from late night briefings and inadequate facilities to unreported workplace bias and repeated questions of authority. These are all daily realities that I'm quite sure all of you are also familiar with. And yet, despite these burdens, countless brilliant women have excelled in this profession because they believe in its ethos. To my mind, this is precisely why representation matters. Every woman who takes her place on the bench sends a clear message to those still facing these obstacles. Your perseverance is not unseen, and it is not in vain. When a young female lawyer sees another woman presiding a court, not as an anomaly or outlier, but as a matter of course, something in her psyche shifts. Aspirations becomes tangible, and belonging becomes unambiguous. Let me be very clear. Any discussion we shall have today is not an argument for preference. It is an argument for a fair starting line, equal opportunity, equal responsibility, and equal space to demonstrate competence. Today, we must deliberate on strengthening the architecture of opportunity, which breeds a legal landscape where deserving candidates rise not as tokens, but as natural choices. Once we accept that access is the real question, the next inquiry is unavoidable. How far have we progressed in securing it? That's the question. Well, I can say with some satisfaction that meaningful steps have been taken even before discussions on reform gathered wider momentum. Supreme Court had already moved substantially toward greater inclusion. And rather, I should say the judiciary as a whole, not the Supreme Court alone. In that spirit, the court exercised its extraordinary power to address the glaring underrepresentation of women you have recently seen in the elected bodies within the legal profession. We directed that in state bar councils, at least 30% of the seats must be occupied by women advocates. We also issued similar directions to the Bar Association on pan-India basis. I would implore all of you to not view this as merely a symbolic exercise. It is, in fact, a pragmatic step aimed at correcting the structural imbalance that prevents women from having a real voice in the institutions that shape the future of the bar. Elevation, after all, is not a simple or instantaneous process. It requires nurturing the pipelines at its very source. And if the pipeline is narrow at its source, the bench cannot later be broad. However, the responsibility does not rest with the court alone. That we need to understand. The system as a whole must be sensitized. Bar associations in particularly have a constructive and indispensable role to play. Members of the bar, particularly our male colleagues, must acknowledge and accept a simple reality. And what is that? Women members are not seeking concessions. They are seeking fair and appropriate representation, which has long been due. Only when the profession itself internalizes this truth will the pathway to the bench become clearer. Another area of reform lies within the High Court collegiums. They too must recognize that the moment for measured action is not in the future, it is now. Where suitable, meritorious women members of the bar are available, their consideration should not be an exception, it should be a norm. And where I will go into the extent that where in certain high courts or district courts, suitable candidates within a particular age bracket are not immediately available, that should not become a barrier. I earnestly request the High Court collegiums to widen the zone of their consideration and include women advocates practicing in Supreme Court who belong to that state. I point out these solutions not because they are extraordinary, but because they are entirely within the existing framework. We must acknowledge that institutional intent is no longer enough. It must always be accompanied by institutional imagination. Having said that, there are encouraging signs. Multiple women are currently serving as Chief Justices of High Courts. With the elevation of my sister Justice Lisa Gill, now there will be 3 Chief Justices in the High Courts. Certain High Courts also deserve particular commendation, like my own parent High Court Punjab and Haryana, for instance, has demonstrated notable progress with as many as 18 sitting women judges. The Madras and Bombay High Courts have also about a dozen female judges each. Equally significant is the encouraging scenario in our district judiciary, which offers perhaps the clearest indication of what lies ahead. With women comprising approximately 37% of the working strength of judicial officers in the district level, the foundation is steadily strengthening. Friends, this is not a simple statistic. I would argue it reflects a generational shift. If we speak of a pipeline, which I illustrated just now, it is here that it is visible widening. And when the base of the system reflects greater inclusion, it is only a matter of time before that strength finds expression in the higher judiciary also. I may also add that the development of judicial and legal infrastructure can meaningfully advance the cause of equality. The expansion of virtual hearings, improved digital access, structured monitoring, or supportive facilities all can strengthen inclusion without diluting standards. Even the creation and proper allocation of professional workplaces or chambers within court complexes for women advocates will make tangible differences to their professional lives. These developments indicate that the momentum has begun, the environment has been created, and with steadily increasing numbers of women entering and excelling in the legal profession, it is both natural and necessary that their presence on the bench grows suitably. Yet we must guard against complacency. While momentum is encouraging, it is not completion. We must all understand a reform of this nature is not an event, it is a continuing process. The cultivation of institutional fairness requires persistence beyond individual tenures and beyond individual personalities. It may not reach full fruition within my term of office, nor within that of maybe my sister and brother judges. That, however, cannot and should not determine the depth of our commitment. If progress is to be meaningful, it must be institutionalized. The story should not be that one individual secured greater representation. Rather, it should be that the Supreme Court of India and the high courts across the country consciously embedded fairness into their processes. When that happens, representation will no longer depend on personalities or moments of resolve. It will stand anchored in the structure of the institution itself. And that ultimately is how enduring change is made. Thank you very much, ladies and gentlemen, giving me this opportunity to share my views. Thank you very much. Jai Hind, Jai Bharat.
Thank you so much, sir. The demand can be fulfilled when it comes from the top.